Your Honor will be relieved to hear that I do not have an hour and a half long PowerPoint to present to the court, but I do want to talk for a couple minutes. I'll start with the big picture of what the evidence shows, both through the trial and then the evidence that we've added today. Just, a few simple bullet points here. The defendant didn't like Quentin. There's credible evidence of that. The jury evidently found it credible. Had some witnesses come in and dispute that today, but I would submit that they are not the most objective sources of information on that. Her dislike for Quentin was not a result of any drug problem. It's totally independent of that. If you combine the testimony of Melanie Bowling and Talia McCarta and Michelle McCarta, it spanned his entire life. Has nothing to do with drugs whatsoever. She murdered him, and the jury has found that she had the specific intent to kill when she did so. And this sets this case apart from cases in which the jury only makes a finding of guilt on felony murder, but acquits on malice murder. This jury did not do that. And there's a great deal of aggravation. Some of the aggravation is charged as independent offenses, concealing the death and false statements and false report of a crime and so forth. Some of it is not. The aggravation includes her covering it up in a deliberate, calculating, and very manipulative way. It involved totally shameless and reprehensible attempts to blame people without conscience, right? Just no compunction about blaming other people who were totally innocent of this and who in fact loved Quentin very much. She behaved in a way that shows a total lack of remorse, both during the investigation, when on day one she's asking Paul, hey, do you got some weed to smoke when we get home? On October 18th, when the police have announced that they're about to start searching for Quentin's little body in the landfill, she's out at Stingrays getting drunk and flirting with the waiter in a continuation of what we talked about at trial as to kind of what the theory was here, that a lot of this had to do with her need for male attention. This seems to have continued. She behaved in a way that shows absolutely no remorse and no compunction about what she did during her pretrial investigation and during the trial itself, as we've tried to show here today. Even to her mother, her closest confidant, who taught her to take responsibility for your actions, which is something that Billie Joe Howell, has done. I mean, she did it here today. She talked about all of her missteps and how she pulled herself out of them. She took no responsibility even to her mother, who taught her those things and was her close confidant. It's one thing to not admit to the police what you did and not take any responsibility to the police. It's kind of another thing to treat your mother, whom you claim to love so much, the same way. The upshot of all this is that she just doesn't seem sorry at all. She really doesn't seem sorry. She seems sorry that she got caught. She seems sorry that she's gonna. She had to stand trial. She seems sorry that she's going to go to prison for a long time. The only question here is whether it's forever for her. But she doesn't really seem sorry about what she did. If she had been sorry about this at any point, there were a million off-ramps. After killing Quentin, she could have just not thrown his body in a dumpster. We get these abusive head trauma, child homicide cases. In typically, the fact pattern is the perpetrator does the thing, they do the act, and then they just say to the police, oh, I found him in the crib like this, and I don't know why he's not breathing, or there was some sort of accident or something like this. She could have played it that way after killing Quentin. She could have. So that's like off-ramp number one, is just don't throw him in the dumpster. Don't do that. And at any time, she could have stopped telling lies, just refused to talk at all. Certainly didn't have to blame anybody else. She could have just said she didn't know. Certainly didn't have to blame like 3 or 4 different people. So she doesn't seem sorry at all, and she's taken no responsibility, and she seems to sort of think that she's kind of at least playing as though she's the victim. I would ask the court to look at this letter to WTOC and really read it, in which she's playing the role of like a detached commentator evaluating the evidence, and she'd sure love to know what happens, but the problem is she just keeps running into these gaps in the evidence, and that's really frustrating to her because she wants to know what happened. And it's just so infuriating and bizarre because obviously she knows what happened because she's the one who did it. It is bizarre, it is infuriating, and it is quite frankly insulting to everyone's intelligence, and really makes a mockery of the process. There's been this effort to blame it on drugs and mental health issues. Mr. Hilliard is too smart and savvy and experienced to try to do that directly, because I think he knows that you don't come in and say, Judge, it was the drugs. But some of the witnesses maybe don't have that level of experience and were willing to just say it was the drugs. The drugs did it. To medicalize it, to kind of shift responsibility from her onto her conditions or these substances. Lots of people have tough upbringings. Lots of people take drugs. But very few of them kill their own child. We're familiar with words like homicide, killing somebody else, suicide, killing yourself, fratricide, killing your brother, or biological, or your brother in arms. Even infanticide. There's a word for this, the court may or may not know, filicide, killing your own child who's not an infant. A lot of people don't know that word, and the reason a lot of people don't know that word is it just doesn't happen often. It is a heinous thing to do. So heinous, in fact, that people do it very infrequently, and that's what she did. The drugs did not do that. I'll point out something about the drugs in this case. It's easy for people to get up there and kind of say without really examining like how this would work or what this really means is, the drugs caused her to do it. Let's look at the substances that she was on that night. Cocaine, Percocet, marijuana. None of these substances are the kind of substances that are going to induce like a psychosis and essentially turn you into a different person or make you do something that you have no control over. You hear about that sort of thing, I guess like bath salts and things like that. But that is just that's not what she was on. It wasn't anything like that. And it's a total red herring to say that the drugs did it. What she did to him was something that was inside of her already. It was inside of her already. Maybe the drugs lowered her inhibitions. Maybe they acted as an accelerant. Maybe they're like, the match to the candle or something like that. But they caused her to do what she did. She did it. The drugs are not responsible for it. She is. She just did a wicked thing, and she needs to take responsibility for it. And so our recommendation is a total sentence of life without the possibility of parole, plus 65 years and a fine of $117,000. The maximum that I calculate is available under the law. I've emailed the court separately that the count by count breakdown, I won't go through that here, and the justification for the fine. That is essentially our goal there is to ensure that if the defendant ever attempts to profit from her crimes by signing a book deal or taking a paid interview, that there will be an existing financial obligation that will cause at least some of the money, up to $117,000, to be diverted to defray some of the costs associated with her conduct in this case. Now, that brings me to kind of the last question, which is really separate and apart from whether the court adjudges a fine here, is why life without parole and not life? That's really the only question, is whether the court is going to impose the additional punishment of the life sentence never being parolable. And you know, it's a reasonable thing for the defense to say, gosh, life is a serious sentence. 30 years before you become parole eligible is a long time. And that's true. And we are here asking the court to go above that and to impose the maximum. And I'd like to kind of defend why and argue why. When we talk about sentencing, we talk about the principles of punishment. There are a number of them. We learn them in law school, and they come up in sentencing arguments, and Mr. Hilliard has gestured at some of them, rehabilitation and things like that. And I'll just kind of walk through these. One of the principles of punishment that we talk about is incapacitation, which is incapacitating the offender from committing a similar offense. Somebody is so dangerous, they just need to be locked up to keep them off the street. Now, can I say that incapacitation, the need for incapacitation, justifies the additional sentence of life without parole here? Not really. I don't think that principle of punishment is a justification. That she's so dangerous that life with the possibility of parole is not sufficient. Next, we have deterrence, both specific and general. Specific deterrence meaning the need to have a serious enough sentence that it deters her from doing something similar, and general deterrence, that it deters other people in the community who might contemplate doing the same thing from doing it. I don't know that that's really in play here either. You know, I don't think she needs life without parole versus life to not do it again. And I don't know that there's anybody out there who's contemplating killing their child who's going to go through with it if she gets life without the possibility of parole, but won't go through with it if she gets life without the possibility of parole. And then we have rehabilitation, the need for rehabilitation. I cannot say that there's no chance she could be rehabilitated, that she's totally beyond rehabilitation. I think the court could reasonably find that. I think there's a lot of evidence here that she is incorrigible. But I can't say for sure that after 30 years, she's so beyond the hope of rehabilitation that she has to stay in on that basis, that she just can't be rehabilitated. And so where we end up is at the last principle of punishment that I know of, and that is retribution. Punishment because you deserve it. A harsh punishment because you deserve it by virtue of what you did and how you acted. Not dressed up as being, towards rehabilitation or towards deterrence, but just punishment as a matter of moral desert. This sometimes gets a bad rap. I've heard it described as the least morally defensible principle of punishment. That somehow punishment dressed up as being for rehabilitation or being for deterrence is somehow morally acceptable. That punishment simply because you deserve it, because of what you did. But I don't think that's right. I don't think that's right. For one, it is the principle of punishment that, to the state's view, most lines up with the average person's intuition about what punishment is for and their concept of justice. That it is actually okay and right and good to punish people harshly simply because they deserve it and not justify it further. You have to get really educated to learn that universal moral intuition is actually a bad thing or somehow wrong. Now, we sometimes kind of accept that what people say about retribution, retributive punishment, is true, that it is less defensible than the other principles of punishment. But there's not a consensus on this. That is actually not the consensus view. there are a lot of very smart academics and legal philosophers who continue to defend and make the case for retribution. There's an article by a legal academic, Dan Markle. He was a professor at Florida State Law School. Coincidentally and tragically, he was actually murdered himself. But he wrote on retributive punishment. In a 2011 article that I found, he talks about how it has both a communicative function and an expressive function. That punishment, retributive punishment, because you deserve it, a harsh sentence, just because you deserve it and you did a really bad thing, communicates to the defendant the seriousness of what they did and society's lack of acceptance for it. And it performs an expressive function too. It communicates to the defendant the seriousness of what she did, and it forms an expressive function. It expresses to society how seriously the court takes behavior like this. And, you know, I've got some long quotes in here from these articles. I think I will not read them. I think I will just kind of restate that in my words. Another way of saying this is that a severe sentence, here the harshest one under the law is what we're asking for, sends a message to both her and to the community. And she needs the message. Quite frankly, she needs the message. She doesn't get it. She needs to receive a solemn statement from the court that for an offense like this and for aggravating circumstances like this, the only punishment that will do, the only punishment that will adequately get through to her the seriousness of what she's done and just how unacceptable her actions are, is the maximum sentence under the law. That appears to be, at this point, the only thing that the court can do to try to get through to her. This letter to WTOC is dated September of this year. She still doesn't get it. And the court should send her a message. One, this is nonsense. And two, you deserve the most severe sanction that the court can lay on you. The court should send the community a message too. To the people that cared about Quentin, who knew him during his life, you know, he was a child in their lives, and to people who came to know him only after the defendant killed him. And why do these people care about him? Simply because he was a child in their community, and that is enough. The court should send a message to them that their intuition about how monstrous it is for a mother to kill her own child and then act like she acted in the aftermath, and what the price tag for that ought to be, that intuition that they have is entirely correct and is shared by the justice system and by the court, which is really their justice system and their court. Thank you, Your Honor.